Imagine dedicating years, really pouring your heart and soul into a dream career, becoming an educator, only to see it just grind to a halt. All because of a single accusation and the whole thing fueled by, well, digital evidence. That's really the heart of the story we're diving into today.
It really is, and it shines a light on how, every text, every message, it leaves a footprint, a permanent one. And those footprints can completely shape or even shatter a life, especially for people in positions of authority.
Absolutely. So our mission today is to walk you through this unfolding case involving Darian Rogers. She's 22, was a student teacher at Rouse High School in Leander ISD near Austin, and she's now facing some really serious felony charges over an alleged improper relationship with a 17-year-old student.
Yeah, and for this deep dive, we're pulling from a few key places. There's the FOX7 Austin News report on the arrest itself. We've also got insights from a former sex crimes prosecutor, shared on the Law and Crime Network. Gives a good legal perspective.
Right, and we've looked into Texas sexting laws specifically, using details from a law office resource. We want to pull out the important bits for you, not just what happened, but really why it matters. Looking at the legal angles, the complexities, and honestly, the surprising details that this digital trail revealed.
Exactly. I want to give you that shortcut, so you're informed, get those aha moments, those facts that really stick.
Okay, so let's start with the main person here. Darian Rogers, 22 years old. She was doing her student teaching at Rouse High School. Arrested, charged with a second-degree felony. The specific charge is improper relationship between an educator and a student.
And the accusation involves a 17-year-old student. Now, what's interesting here, adds another layer, is that he wasn't just a student at the school. He also worked with Rogers at H-E-B, the grocery chain.
Ah, okay, so a dual relationship context, school and work.
Exactly, and that can complicate things.
So the timeline. Rogers starts her student teaching in January 2025.
Right, and the investigation doesn't kick off until April. That's when a report comes in.
Then the arrest happens May 16th. She's booked into Williamson County Jail.
And released pretty quickly, the next day, May 17th, on a $20,000 bond.
So the big question is, how did this all come to light? How did the investigation actually begin?
Well, it started back in April. Another student at Rouse High School went to a teacher. This student claimed they had personal knowledge of an inappropriate relationship happening.
Okay, personal knowledge. That sounds significant.
It is. This student then apparently spoke to a school administrator.
Yeah.
And they claimed that Rogers, who was their supervisor at H-E-B and a student teacher, was allegedly engaging in sexual relationships with several of her coworkers from H-E-B who were also Leander ISD students.
Wow, okay, that's a pretty explosive claim involving potentially multiple students.
A very strong claim, yes. And the student didn't just make the claim.
They brought proof.
Some initial evidence, yeah. A voicemail, apparently from Rogers herself. And in this voicemail, she allegedly admitted sending explicit photos to the 17-year-old male student we mentioned earlier.
A voicemail admission. That's quite something right at the start. Powerful evidence.
Absolutely. And this is where you really see the power of electronic evidence cutting through denials. Because a 17-year-old student, initially, he denied the relationship to the police.
Flat out denied it.
Yep. But then, crucially, he let the police see his phone, his texts with Rogers.
And what did they find?
They found messages discussing the Plan B contraceptive pill.
Ah. That strongly suggests a sexual encounter happened.
Exactly. And faced with that digital evidence, the student then admitted, yes, they had a relationship.
So the digital trail directly contradicted his denial.
Right.
What about Rogers herself? What was her story?
Similar pattern. First, she denied it, described the relationship as more like a big sister and little brother thing.
Okay, trying to frame it as mentorship, maybe.
Something like that. But again, when the police confronted her with the text evidence...
She changed her story, too.
She did. She admitted to having sex with the student, saying it was one time in his truck.
Yeah.
Happened in a parking lot near H-E-B where they both worked.
So think about this. You're faced with your own text messages. How does a defense lawyer even start to challenge something like that in court? It seems so concrete.
It's incredibly difficult. And it didn't stop there. The police did a full forensic copy of Rogers' phone.
And found more.
Oh, yes. Very telling stuff. Like a text message she sent to the student before she even started teaching at Rouse, basically telling him, hey, don't make inappropriate comments around school staff, because she was interviewing there. Suggests awareness, maybe.
Definitely raises questions about intent and awareness early on. What else?
Even more direct evidence. A video of her actually taking the Plan B pill.
A video she recorded herself.
Recorded herself taking it and sent the video to the student. along with a screenshot of the receipt for the pill.
Wow, sending video proof and a receipt? That's not subtle.
Not at all. And it just hammers home this point for you. In this day and age, nearly every interaction can leave a digital trace. Things you think are private or maybe just casual, they can become incredibly powerful, often damning evidence later on.
Especially when they directly contradict what someone initially says.
Precisely. It makes those initial denials crumble. You might argue about context, maybe coercion during questioning, but the digital data itself, that's hard to argue away.
And things got even more complicated, didn't they? There was mention of another potential relationship.
That's right. During the investigation, detectives found another text thread, this time between Rogers and a friend. And in these texts, Rogers apparently described a previous sexual relationship.
With another student.
Yes, with another male subordinate from HEB, who was also 17 at the time, and also a Leander ISD student.
So a potential pattern emerging.
Exactly. And connecting this to the bigger legal picture, that former sex crimes prosecutor we mentioned, they pointed out that prosecutors often use this kind of information. They can use it to show a pattern or practice, or what lawyers call a modus operandi, an MO, a signature way of operating.
So this provides another key insight for you listening. It's often not just about the one incident in court.
Right. Prosecutors tried to build a narrative, show this wasn't a one-off mistake, but potentially part of a pattern of behavior. And that makes it much, much harder for the defendant to explain away the current charge as some kind of misunderstanding or isolated event. It paints a broader picture for the jury.
Okay, so amidst all this, how did the school, Rouse High School, actually respond?
Well, the principal, Vincent Hawkins, sent a letter to parents and families pretty quickly on May 16th, the day of the arrest. The main message was emphasizing student safety. And he was very clear on a few points.
Like what?
He stated that the alleged misconduct did not occur at school during school hours or at any school-sponsored event.
Trying to create distance.
Right, locating it off campus outside of school functions.
Exactly. He also stressed that Rogers was not a Leander ISD or Rouse High School employee. She was just there completing student teaching hours.
So drawing a line between her status and being a full employee? Yes. And he confirmed she was immediately removed as soon as the district found out. They notified her university, UT Austin, and the Texas Education Agency, the TEA.
And they cooperated with the police investigation.
Fully cooperated, according to the reports.
The district also clarified what exactly a student-teacher role entails, right?
They did. Leander ISD explained it's basically the final step before getting certified, part of the college requirement. Rogers was assigned to Rouse for that spring semester starting January 2025. Had to be on campus 5 days a week.
Working with a regular teacher.
Yeah, assigned to a cooperating teacher, mostly observing but likely starting to teach too. And importantly, she had to do all the district compliance training, review the staff handbook, which explicitly includes rules against relationships between educators, even student ones, and students.
So she should have been aware of the rules.
Absolutely. The district even pays student teachers a stipend, about $1,250 in this case. So they are integrated into the system, even if temporarily.
Which leads to the question of authority.
Right. What does this all mean? Even if the alleged acts happened off school grounds, outside school hours, a student teacher is still absolutely considered to be in a position of authority over students at that school.
That power dynamic is key.
It's central to these laws. That imbalance of power exists whether you're a full-time, tenured teacher or someone in a temporary training role like a student teacher. It's about the role, not just the employment contract.
Okay, let's shift gears a bit and talk about the specific Texas laws involved here, because it gets a little complex, doesn't it?
It does. First off, the basic age of consent in Texas is 17.
So legally, a 17-year-old can consent to sexual activity with an adult, like someone 22.
Correct. But here's where it gets really interesting, and frankly, quite tricky for you to wrap your head around sometimes. Texas law has specific rules about sending explicit images, what we call sexting.
And this is separate from the age of consent for physical acts.
Exactly. A 17-year-old can legally send sexual images, but generally only to someone close in age within 2 years is the typical rule. Sending those same images to someone older, say 20, 21, 22, like Rogers, that can potentially be an offense for both the sender and the receiver.
So the 17-year-old could technically commit an offense too by sending.
Potentially, yes, depending on the specifics and the exact statute applied. It highlights a weird paradox in the law.
So what are the key laws we're talking about?
Well, there are a couple. One is Texas Penal Code Section 43.261. This one deals specifically with minors 17 or younger sending or having visual material of another minor engaging in sexual conduct.
Okay, minor to minor transmission.
Right. And it has that Romeo and Juliet exception we mentioned. Basically says it doesn't apply if the picture is just of the sender or someone else who is also a minor and not more than 2 years older or younger, and they're in a dating relationship.
So designed to protect teens in relationships from felony charges for sexting each other.
Kind of, yeah. But that exception have limits. It doesn't cover adults receiving images from minors or significant age gaps.
Then there's a more serious law.
Yes, Texas Penal Code, Section 43.26. This is the broader statute covering possession or promotion of child pornography. It applies to anyone who knowingly possesses or accesses visual material of a child defined as younger than 18 engaging in sexual conduct.
And this one is stricter.
Much stricter. Unlike the other law, this one has no age limits or age-related defenses for the person charged. Doesn't matter if the person depicted consented or sent it willingly. Doesn't matter if the person charged is only slightly older.
So just possessing that image, if the person depicted as under 18, is a potential felony.
A serious felony, yes.
Yeah.
It signals a zero-tolerance approach to adults having explicit images of minors.
So just to clarify for everyone listening, sexting in this legal context in Texas
Generally means sharing or receiving sexually explicit images, videos, or even messages, especially when anyone under 18 is involved. Sending them, asking for them, just having them on your phone if they depict a minor, it's illegal, even if the minor consented or sent it themselves. That Romeo and Juliet exception is narrow.
And the penalties reflect that seriousness?
Absolutely. Under that first law, Section 43.261, it could be anything from a Class C misdemeanor, like a traffic ticket fine, up to a Class A misdemeanor, maybe a year in jail, $4,000 fine, depends on the specifics.
But the child pornography statute, Section 43.26?
That's felony territory. Serious felonies. We're talking potential prison sentences ranging from 2 years all the way up to 99 years or even life, plus fines up to $10,000. It really depends on the exact charge and circumstances.
So those are incredibly severe potential consequences. And it goes beyond just jail time and fines, right? You mentioned collateral penalties.
Yes, and this is crucial. Beyond any criminal sentence, a conviction like this in Texas triggers a whole cascade of what are called collateral consequences.
Yeah.
These are penalties that aren't part of the official sentence, but dramatically impact someone's life long term.
Like what kinds of things?
Oh, it's a long list. Major difficulty finding a job or keeping one. Trouble finding housing, landlords might refuse to rent, loss of voting rights, loss of firearm rights, potential immigration problems if not a citizen, child custody issues.
And for someone in teaching,
Mandatory sex offender registration is a big one, community service, probation, and definitely suspension or revocation of professional licenses, like a teaching license.
so this brings us to the third key insight for you listening. For someone like Darian Rogers, aiming for a teaching career,
These collateral penalties are absolutely devastating. Career ending, almost certainly. That dream she worked towards for years, likely gone. It just underscores how profound and far-reaching the consequences are way beyond the courtroom.
it's really quite tragic when you think about it from that angle. She was a senior at UT Austin, right? Special education major, about to graduate this month.
Exactly. And that former prosecutor confirmed it, even if this ends in some kind of plea bargain, maybe probation, no jail time.
Yeah.
Her teaching career is almost certainly over before it began.
Because schools do background checks.
Thorough background checks.
Yeah.
And online searches. They'd find this arrest, the charges. They would be extremely hesitant to hire someone with this kind of record, especially for a role involving children.
Understandable. Public trust is paramount.
Absolutely.
You mentioned plea bargains. We learned most cases like this actually don't go to a full trial. Why is that, and how does that process work?
Well, trials are risky and expensive for both sides. Prosecutors look at the strength of their evidence, which seems pretty strong here with the digital stuff. They also consider if the victim is willing to cooperate and testify, and whether the defendant seems to be accepting responsibility.
Are there things that might make a prosecutor offer a plea deal, maybe with less severe consequences?
Possibly. Mitigating factors could play a role. Roger's age, the fact she was a student teacher, not a fully certified one yet, maybe first offense status. Things like that might lead towards an offer involving probation instead of prison time.
But it's still a conviction with those collateral consequences.
Oh, absolutely. A plea bargain is still typically an admission of guilt to some charge.
And this brings up an important point for you to think about. What if the 17-year-old student, the alleged victim, decides he doesn't want to testify? Does that matter?
It matters a lot. It definitely makes the prosecution's job harder if their main witness is reluctant or refuses to cooperate.
So the case could fall apart?
Not necessarily. They might have other evidence, like the text, the voicemail, maybe the friend's testimony about the previous alleged relationship, but it weakens their case considerably. Prosecutors have to balance the victim's wishes against their duty to protect the wider community, though. It's a tough call for them.
And does the timing of these cases play a role?
It can. These cases often take a while to get to trial. 6 months, maybe over a year, isn't uncommon. Plea deals can happen faster. Defense attorneys sometimes try to delay things. Why? Because over time, witnesses, including victims, can sometimes lose interest, move away, or just become less willing to go through the ordeal of testifying. Memories fade, lives move on.
Interesting strategic element there.
Definitely part of the legal maneuvering.
Okay, so let's wrap things up. Today, we've really taken a deep dive into this unfolding case in Texas. It shines such a bright light on the serious consequences of improper relationships between educators and students, especially now in this digital world.
Yeah, we've seen how incredibly specific details, voicemails, texts about Plan B, even a video become absolutely crucial evidence, and how the complexities of Texas law, that interplay between age of consent and sexting rules, can have these massive life-altering impacts.
So as you reflect on all this, maybe consider this, given that huge power imbalance that exists in any educator-student relationship, even for student teachers.
And knowing the consequences are so severe, often ending careers, how vital is it for anyone going into education to understand not just the letter of the law, the specific statutes?
But also those broader ethical lines, and to really grasp how easily digital evidence can completely change their life story, personally and professional.
And maybe one final thought for you. What's the responsibility here for the institutions? The universities training teachers, the school districts placing them? How much responsibility do they have to make these boundaries crystal clear for everyone, even people in temporary or training roles, before they step into that position of trust?